Rosalind Pryor, educational diagnostician and speech-language pathologist, and I'm here today to talk to you about the IDEA Ideas Act that goes along with disabilities in the United States. So the Individuals with Disabilities Act, which is IDEA, requires public schools to provide special education and related services to eligible students, but not every child who struggles in school qualifies. So to be covered, a child's school performance must be adversely affected by the disability in one of 13 categories. And so I'm going to go over those 13 categories. But I want to tell you a few more things about IDEA. It refers to the special education process, and it serves as a written plan for every child with a disability that must be reviewed and revised in accordance with IDEA. It applies to all public school students receiving special education and related services, enables the child to participate in progress in the general education classroom, requires collaborative team effort for designing an educational program. It improves educational results and outcomes for children with disabilities. IDEA sets eligibility standards that school districts must follow in determining whether a child qualifies for special education or related services. As such, the child must fit in one of the classification criteria as having a disability. And that disability must be significantly affecting the child's ability to learn or educational performance. This is an IEP team decision based upon the data collected, the assessment done, the input of the parents, educators, and other team members. So let's talk about the 13 disability categories. The one that is most prevalent is specific learning disability. And the umbrella of SLD covers a specific group of learning challenges. These conditions affect a child's ability to read, write, listen, speak, reason, or do math. And here's some items that could fall under this category. It could be dyslexia. It could be dysgraphia. It could be dyscalculia. It could be auditory processing disorder, or it could be a nonverbal learning disability. So SLD, like I said, is the most common category under IDEA. And in 2018, 34% of students who qualified did so under this category of SLD. The next category to talk about is other health impairment. Now, this umbrella term, other health impairment, covers conditions that limit a child's strength, their energy, or alertness. For example, ADHD falls under other health impairment, which impacts attention and executive functioning. The next category, the third one, is autism spectrum disorder, or ASD. Now, ASD is a developmental disability. It covers a wide range of symptoms, but it is mainly affects a child's social and communication skills, and it also can affect their behavior. The fourth category is emotional disturbance. Now, various mental health issues can fall under the emotional disturbance category. They may include anxiety disorder, schizophrenia, bipolar disorder, obsessive compulsive disorder or OCD, and depression. Now, some of these may also be covered under the other health impairment category as well. The fifth one is the speech and language impairment. Now, this category covers difficulties with speech or language. Now, common example is stuttering. Other examples are trouble pronouncing words or making sounds with the voice. It also covers language problems that make it hard for kids to understand words or express themselves adequately, especially at school. The sixth category is visual impairment, and it also includes blindness. Now, a child who has eyesight problems is considered to have a visual impairment. Now, this category includes both partial sight and blindness. If eyewear can correct a vision problem, then it probably doesn't qualify. The next category, number 7, is deafness. Kids with a diagnosis of deafness fall under this category. They are kids who can't hear most or all sounds, even with a hearing aid. Some may have cochlear implants, some may have just hearing aids, some may need other devices to help them hear within the classroom setting. The next one is hearing impairment. This term, hearing impairment, refers to a hearing loss not covered by the definition of deafness. This type of loss can change over time. Being hard of hearing is not the same as having trouble with an auditory or language processing problem. Deaf and blind is the next category. Number 9, kids with a diagnosis of deaf or blindness have both hearing and vision loss. Their communication and other needs are so unique that programs for just the deaf or blind can meet them. The next one is orthopedic impairment. Now, orthopedic impairment is when kids lack function or ability in their bodies. For example, cerebral palsy. Number 11 is an intellectual disability. Kids with this type of disability have below average intellectual ability. They may also have poor communication, self-care skills, and social skills. They also may have Down syndrome. In one example of an intellectual, this is one example of an intellectual disability. Number 12 is traumatic brain injury. Now, this is a brain injury caused by an accident or some kind of physical force. Number 13, and the last disability category, is a child with multiple disabilities. And that child has more than one condition covered by IDEA. Having multiple issues creates educational needs that can't be met in a program designed for any one disability. Now, learn how to find out if your child is eligible for special education. When kids are found eligible, the next step will be to create an individual education program, or IEP. Now, for kids who are in preschool or younger, you may want to learn about early intervention services in your state. Okay, now we're going to talk about parents and due process. Now, at all stages, parents are key members of the IEP team and an integral part of the IEP process. Parental input and permission must be obtained throughout. For example, with regard to assessment plan, programs, services, goals and objectives, and placement. These all require the parents' input and permission. In fact, IEP does not go into effect until the parents agree to it and sign it. Whenever there is a dispute or a disagreement between parents and the school regarding a child's special education plan or program, there are various avenues for resolving the differences. Disagreements may arise over evaluations, goals, services, placement, and other issues. In most cases, these issues can be worked out in a regular meeting. You don't have to go to a hearing or anything like that. By sharing your concerns and utilizing a cooperative team approach. However, if necessary, parents have other options. They can go to mediation, they can file a formal complaint, they can go to a due process hearing. Now, the mediation process is highly recommended for resolving disputes for the following reasons. Approaches problems collaboratively, non-adversarial in nature. It also can resolve conflicts without the need for litigation, focuses on the child's needs, and tends to be cost effective. Parents may file a formal complaint, however, if they believe the school district is violating their rights regarding the laws and regulations pertaining to the students with disabilities, either the evaluation, the provision of services, implementation of the plan, and so on and so forth. To that end, parents should request a copy of their legal rights from the school or district special education department. You should have already received this at the beginning of the process, but if you have not, you need to request a copy from your special education department. Now, the basic special education due process hearing under IDEA goes as such. Now, when IDEA is reauthorized, and is reauthorized all the time, the special education process changes. So make sure that you are up on the most current information regarding the due process approach that is the most current. Now, if a child, identification of a child as possibly needing special education and related services. Let's talk about that. Generally, a referral is made by a parent, a teacher, or school professional requesting an evaluation to see if a child has a disability. Then an assessment plan is developed by the school's multidisciplinary evaluation team, addressing all areas of suspected disability. The assessment plan must be developed within a reasonable amount of time, such as 15 calendar days. And parents must give their written consent to the assessment plan before proceeding further. Now, the evaluation of the child. The evaluation is generally referred to as a psychoeducational evaluation and may involve a battery of tests to measure cognitive abilities, academic achievement, and perceptual motor, memory, language, and other processing skills. Now, multidisciplinary team of school professionals such as school psychologists, the special education teacher, educational evaluator, the school nurse, or the speech language pathologist. They are all involved in the evaluation if needed. Now, results will be used to decide the child's eligibility for one of those 13 categories for special education and related services to make decisions about an appropriate educational program for the child. Decide eligibility. Now, based on the results of the evaluation, as well as other information provided by the parent, such as reports from evaluations conducted outside of the school, the team decides whether the child is disabled, as defined by IDEA. Now, if parents disagree with the school's evaluation, they have a right to take their child for what's called an independent educational evaluation, or an IEE, and can ask the school system to pay for it. Parents may also request a hearing to challenge the eligibility decision. Find child eligibility services. Now, if found to be a child with a disability, as defined by IDEA under any of the 13 disability categories, the child is eligible for special education and related services. Now, within 30 calendar days after determining that a child is eligible, the IEP team must meet to write an IEP for the child. Note this though, the timeline is translated in different ways by school districts across the United States. For example, the timeline may be within 15 calendar days after receiving a request or referral. The school proposes a written assessment plan and informs parents of their due process rights. It could be the parents must agree with the school district's assessment plan or request a different one. Once the parent signs the assessment plan, the school has 50 days, not counting school vacations, to perform and complete the assessment and hold the IEP meeting. Now, scheduling of the IEP meeting. The school schedules the IEP meeting with parents, teachers, and other IEP service providers, and students if appropriate for their age. Now, parents must be given sufficient notice about the meeting and be informed of its purpose, as well as who will be attending from the school district. They have to let you know who will be attending the meeting. Now, parents have the right to invite people to the meeting who have special expertise in different areas and are knowledgeable about their child. Holding of an IEP meeting and writing of the IEP. So the team must meet to discuss the child's strengths, areas of need, and present levels of performance. By the end of the meeting, an IEP is written with input from all the participants at the meeting. Now, the parents must give their consent to all aspects of the IEP, the special education program, related services, placement, goals and objectives, and so forth and so on. If parents disagree and cannot work out their differences with the school district, a mediation process must be available. If that fails, parents must choose either to file a complaint with the state education agency and request a due process hearing. Now, after the IEP is written, let's go over 4 things that you're going to see. You're going to see providing services. Services will be provided. The school must make sure the IEP is being carried out as it is written. Each teacher and service provider must have access to the IEP and know his or her specific responsibilities for implementing all aspects of the IEP, which includes accommodations, modifications, supplemental aids and services, and related services. Number 2, measuring progress and reporting to parents. Now, as mandated in the IEP, the child's progress toward annual goals is measured. Parents are informed regularly of progress and whatever the child is on pace to achieve the written goal by the end of the year. Per IDEA, progress toward IEP goals must be reported at least as often as parents of non-disabled students are informed of their child's progress. Now, we also have to review the IEP. This is done at least annually to determine whether the child has fully fulfilled the goals and objectives set forth. The IEP must be reviewed can be reviewed at any time if requested by either parents or the school personnel. Now, in all cases, parents must agree and sign their permission for any changes in the plan, services rendered, placement, and so forth. If parents don't agree with any of the aspects of the IEP, they should discuss their concerns with members of the IEP team. And we went over the members of the IEP team. There are several options, including additional testing, independent evaluation, mediation, or due process hearing. Now, parents may also file a complaint with the state education agency. Now, the reevaluation of the child. The student must be reevaluated at least every 3 years. It's called a triennial evaluation to determine whether he or she continues to be a child with a disability and to assess his or her current educational needs. In addition, the student may be reevaluated more often if deemed necessary based on his or her conditions, or if the child's parent or teacher requests a reevaluation. If you have any questions, please comment in the comment section below. If you like this video, please give it a thumbs up and subscribe. Thank you and have a great day.